My Lord, may I take the indulgence to mention hearing number 9. It's a 2016 matter. What happened earlier, my friend has submitted the report, land acquisition matter. 7 Nogmas has filed this petition. 2 of them is set over and give me the instruction. They'll be having a meeting next week. So for that instruction, my Lord, if Lordship may take up after 2 weeks, I've taken the consent from my friend, Leonard Chie, Mr. Guru.
On premier by the petitioner, this is matter to 2 weeks.
After 2 weeks, I do.
May I please, Your Lordship? I beg to mention item number 11, jointly requested. Due to conducting counsel is unwell.
You're for?
I'm for petitioner, Lordship.
I'm for respondent 1 to 3.
Joint request?
Yes, Lordship.
On premier by the parties, this is matter to 1 week.
So, may I please, Your Lordship? I beg to mention item number 18 also. Similar thing. I'm for appeal and Lordship. That this matter must become after 2 weeks.
On premier by the appellant, this is matter to 2 weeks.
Highly.
Please, Your Lordship, I beg to mention item number 19, 20, and 21. It's a connected matter. 19, 20, and 21.
Yes.
Your Lordship, let this matter come up after 2 weeks
Why?
due to personal difficulty of the arguing counsel.
It is for settlement, Your Lordship. They are trying to make the settlement.
No, I don't. I think that has. No. That has failed. Who is appearing for?
Philip Nambri and Mr. Sharma.
Manoj Sharma.
Manoj Sharma.
For the complainant?
Manoj Sharma is for the, yes,
Complainant.
He's not here.
No.
no, Manoj, yes, Manoj Sharma is for complainant.
You see, you have to realize that this is a bail matter, number one. Number two, because the parties have tried to settle the matter amicably, so this court has indulged and has given you time, from time to time.
Yes, Lordship.
But now, we cannot just go on like this.
Yes, Lordship.
1 week's time,
Yes, Lordship.
on premier by the petitioner, this is matter to 1 week.
I reply, Your Lordship.
May I please, Your Lordship? I beg to mention item number 12, Your Lordship. Let this matter be taken up after 2 weeks, Your Lordship.
12?
Yes, Your Lordship.
I'm here, ma'am.
You're for?
I'm for a respondent, Your Lordship, 1 to 3.
2016 matter.
We've been informed that there's a bereavement.
Yes, Your Lordship.
Oh. You for respondent
1 to 3.
Council.
JSTC.
on pre-made by the respondent 1, 2, and 3 on account of the Leonard conducting counsel not being able to appear before the court today on grounds of personal difficulty. Matter is adjourned. List the same after 2 weeks.
Much obliged.
Similar pair for item number 16 and 17, Your Lordship. Let this matter be taken up after 3 weeks, Your Lordship.
You are for?
I'm for the petitioner.
On pre-made by the petitioner, this is matter of 3 weeks.
Much obliged, Your Lordship.
May it please Your Lordship, I beg to mention item number 13, my lord. If this matter may come up after 3 weeks, my lord, as the conducting counsel, Dr. Mozika, is currently out of station, my lord.
On pre-made by the petitioner, this is matter of 3 weeks.
Much obliged, my lord.
Lord, I beg to mention, my lord, item number 2 of the supplementary list, my lord. This is that Nehu matter, my lord. My lord has released it from CAV on the last date, my lord. Today, my lord, Miss Paul is not keeping well, my lord. So she needs some time to recover. So I'm praying if this matter can be taken up after 2 weeks, my lord.
Prayer has been made on behalf of the learned senior counsel appearing for the petitioner who is said to be indisposed on grounds of personal difficulty. Prayer has been made for adjournment. No? On the same not being objected to by respondent, the matter shall stand over and be listed after
2 weeks, my lord.
why 2 weeks.
She needs some time to recover, my lord.
2 weeks.
Similar prayer for item number 6, 7 and 8, my lord, from the main list, my lord. That's connected Nehu matters, my lord.
Same order.
Please, Your Lordship, I beg to mention item number 5. The conducting senior counsel is having some family commitment. The conducting counsel is having some family commitment. So you can, so
Please,
I pray
Your Lordship. Your Lordship, in this matter, will be relying on the affidavit which was filed on 23rd of May 2022. However, if required later on, then we'll file our affidavit, Your Lordship.
You are appearing for?
For respondents 2 to 7.
I pray for 3 weeks time. Your Lord.
On prayer made by the petitioner on ground of personal difficulty of the learned senior counsel who is conducting the matter, the same not being objected to by respondent, matter is adjourned. List is seen after 2 weeks.
Supplementary cost list, item number 1.
Lordship, you could recall yesterday, senior has submitted mentioned this case regarding extension of the interim order.
May I please, Lordship? Lordship, I've received some instructions as of yesterday, Lordship, and as per last order, we were supposed to file an affidavit, Lordship. I pray for some time to bring the instructions for an affidavit.
Affidavit? Why? What affidavit?
Regarding status report, Lordship, as per last order, your Lordship has.
Okay. The learned GA, Mr. H. Arwanang, appearing for the respondent, has submitted that the status report as called for by this court could not be filed today, and has accordingly prayed that this matter may be listed after 1 week. In the meantime, the petitioner has prayed that the interim order whereby this court has directed the respondent authorities not to take any coercive action in a matter pertaining to the case of the petitioner be extended. On premium, the same is allowed. The interim order shall remain in force until further orders of this court. On premium, this is matter after 1 week.
Hello, Lodge.
Cost list, item number 1.
I am appearing for the petitioner, Your Lordship.
Yes, what is yours?
I pray for 2 weeks' time to file the rejoinder.
Mr. Devrat, you are appearing for all the respondents?
Yes, sir.
How many respondents are there? Only one? Two?
So this depends. Four respondents.
So you are appearing for all, you have filed the counter affidavit for all the respondents? And a counsel for the petitioner, has submitted that the rejoinder to the counter affidavit filed by the respondent could not be filed today and has sought for some more time for the same to be filed. On pre-meet, the same is allowed. Let the rejoinder be filed within the text date fix. This is matter of 2 weeks.
2 weeks.
2 weeks.
Much obliged.
Item number 2.
Before I start my submission so far this bail petition is concerned, so here there are 4 petitioners, 5 petitioners. Petitioner number 1, if your lordship kindly take up page number 2 of the cause title, lordship. So the name has been wrongly spelled as Ongushuman. So it will be Ongshuman. The you may kindly be avoided, lordship. Here, lordship, these 5 petitioner, they have been arrested in connection with the FIR, which is the subject matter of this case, on different dates. Accused petitioner number 1, 2 and 3, lordship, they have been arrested on 30/3/2023 and as on today 27 days in custody. And accused number 4 and 5, they have been arrested, lordship, on 24/3/2023 and as on date 32 days in the custody. Lordship will kindly find the FIR in page number 18. Here this matter has already been dealt once by this honorable court. If your lordship remember, this is that bikers case. So I again
Miss the CD is here.
Lordship, I again read out the FIR, lordship, to refresh the mind of this honorable court, putting emphasis on the second paragraph of this FIR, lordship. What does it say, lordship? With due respect, I below signed informant would like to state that on 21/1/2023 7:30 p.m. we came to Riders Mania 23 event at Orchid Umiam Lake organized by BO BMC. While registration at gate out of 3 persons, we registered mine and one of our member with name Joydeep De, who we happen to know that our registered gift goodie bag has been taken by opponent party. This second paragraph is important, lordship. I am putting emphasis on this. Accordingly, we registered and gone to the camp. While going towards stage, OP were sitting and drinking alcohol. Suddenly seeing us Jumma Khan attack with big sized wooden log on my head and doing self-defense, I put right hand and it hit my forearm and it was supported with other 3 persons along with Jumma Khan. It is full attempt to murder me. Now, if this is the story, lordship, then Jumma Khan and 3 others makes 4 persons. But here 6 persons were arrested. 1 has been allowed to go on bail and 5 are still languishing in the jail, lordship. Now, lordship, I still continue. Accordingly, we thought we should have talk report with organizer, concerned authority for the legal support of the same night, that is on 21/1/2023. We met organizer and it was for meeting on 22/1/2023 next day at 12 noon. We came for meeting and it was directed by the concerned authority to leave the camp for all of us along with the opponent parties. Seeing the large number of persons, the opponent parties, we decided to go back to hometown, Silchar, fearing threat. After going Silchar, I gone for medical treatment with X-ray, where it has been revealed that forearm has been broken. Accordingly, it was decided that I will follow legal steps for justice. I am filing my FIR and waiting for kind response and justice. Now, Lordship will kindly see there in page number 18, there is a note of the IO, where the IO has registered this case on 26/1/2023 at 10:15 p.m. and it has registered by case Umiam PS case number 041/2023 under section 307, 325, 34. Now, my submission before Lordship will kindly see that if this factual aspect is taken into consideration, then it is not a case of 307, because if a person who is having a hurt and his hand been broken, forearm been broken, he will not be in a position. Lordship, this incident according to him happened on 21/1/2023 at 7:30 p.m. and the meeting took place on the second day on 22/1/2023 at around 12 noon, and there is nothing that he has been given some first aid. Absolutely silent. So therefore, Lordship, there is some doubt regarding whether 307 is attracted or not. Now, if your Lordship take to 325, Lordship will kindly see 325 and 307 will perhaps not go together. 325, Lordship says, punishment for voluntarily causing grievous hurt. Whoever accept in this case provided for under section 335. 335 speaks of provocation. If somebody is done provocation, so it is written that provided for section 335, that means without provocation, voluntarily causes grievous hurt shall be punished with imprisonment of either description for a term which may extend to 7 years and shall also be liable to fine. Now, if I remain your Lordship of the Arnesh Kumar's judgment, if any offence that is punishable till 7 years, then notice under 41 is mandatory.
307 is there.
That is what I am submitting, Lordship. 307 has been added.
Even then, see, now is not the time to go
anyway, Lordship.
To go into
now if I take your Lordship, we are coming to the factual aspect, Lordship. I am not arguing today on the merit of this case. I am arguing on the length of detention and the fact that, Lordship, the statement of the informant has already been recorded, and the investigation that the case diary will certainly speak. Investigation has also extended to a certain stage where perhaps their further interrogation may not be required. Lordship, I kindly see page number 19, Lordship, annexion number 2. This is the forwarding of accused number 4 and 5. Now, accused number 4 and 5, page number 20, Lordship, kindly have a look. Sudeep Singh and Subra Bhumik, they are not named in the FIR, Lordship. Their name is not there in the FIR.
Yes.
So they have been arrested, if you kindly have a look, on 25/3/2023, that is after a period of around 3 months. So within that 3 months, I submit with all humbleness, what has happened in the hand of the informant, it's a matter of trial. He says that I am having rod and everything. That may happen subsequently also. We don't know what has happened within this period of time, because the arrest was not immediate, Lordship. Then Lordship will kindly see, so far as accused number 1, 2 and 3 are concerned, Lordship, they were allowed on an interim bail. They appear for an anticipatory bail. They were allowed to go on an interim bail. And if your Lordship kindly take page number 22 for a moment of time, Lordship.
Yes.
May I kindly read, Lordship, the last paragraph, Lordship, starting from on 29/3/2023, the below noted FIR named accused person appeared at the PS. So they were allowed on the interim bail, Lordship, and after getting the interim bail, they participated in the investigation, they appeared in the PS. Subsequently, what happened, Lordship, will kindly see that their bail were cancelled. Page number 23, Lordship. On 30/3/2023, Robin Singh, Angshuman Dev, Sri Rajbir Singh Raja has been arrested immediately outside the court premises, being rejected their pre-arrest bail by the Honorable Court, because it requires that 438B requires the presence. So they were present, and subsequently they were arrested from there. Then they were taken on 3 days of police custody, Lordship. Very interestingly, I'd like to show your Lordship one very important aspect of this case, which is coming from the forwarding report itself. Lordship, that is in page number 22, last paragraph. They have been interrogated and recorded their statement. It revealed that there was a arguing between Abhinit Srivastav and Sri Robin, Jumma Khan and Rajbir. Your Lordship has kindly got it, Lordship.
Yes.
So there is no, investigation does not say that there was any fight. It says that there was an arguing. So from there also, Lordship, I humbly submit that perhaps 307 and 325 will not be reflected, Lordship. So far, the intention of the accused to abscond is concerned, Lordship. Kindly have a look into page number 25, annexion number 3, Lordship. This is the air ticket of accused petitioner number 1, who, after having coming to know that he has been enlarged on interim bail, has travelled from Delhi to Guwahati and then to Umiam police to appear. So this shows that he never tried to abscond. And on the next day itself, his bail was rejected on the ground, Lordship, that he may try to abscond, and he was with other taken into custody. And Lordship, on the other hand, on the last occasion, Lordship, while Lordship was looking into the case of Jumma Khan, Lordship was pleased to enlarge the co-accused Jumma Khan on bail. Can Jumma Khan, Lordship, is the person whose name comes that he assaulted, and they are saying the other 3 provoked. Now who are the other 3? That is silent. So Lordship, I will pray, Lordship, that with any condition taken into consideration, I am relying upon one judgment of the Honorable Supreme Court, Lordship. Sanjay Chandra versus CBI, para 14, page 9. In bail application, generally it has been laid down from the earliest time that the object of bail is to secure the appearance of the accused person at his trial by reasonable amount of bail. The object of bail is neither punitive nor preventive. Deprivation of liberty must be considered a punishment unless it can be required to ensure that an accused person will stand his trial when called upon. My submission before Lordship, my instruction,
if you are relying on some decision,
Lordship,
this is not an acceptable.
Lordship,
should at least
Lordship,
cite give a proper.
I am very sorry for that. I am very sorry. We will take it back.
Proper copy, which has been duly cited.
I am very sorry.
Indian Kanun is not an accepted mode of citation.
I am very sorry.
You have proper one?
Lordship, presently I am very helpless, Lordship. I will be going for praying for the law of propriety, Lordship, because this Honorable Court was pleased to allow Jumma Khan to go on bail out of the same FIR.
But not necessarily the same on the same consideration.
No, not at all, Lordship, not at all. I am praying considering the length of detention, Lordship, and the investigation might have by this time almost completed, and their detention may not be further required, Lordship. That is my humble submission before Lordship.
Yes.
Please, Your Lordship. Lordship, we have received the CD, Lordship, and on perusal of the same, Lordship, I strongly object to the application made by the petitioner on behalf of the 5 accused persons, Lordship, on the following grounds. Number 1, Lordship, my learned friend had stated that there were different dates of arrests for 3 and for 2. Lordship, the reason being is that on the same date, the police had searched for all 5, but they could arrest only petitioners, the different petitioners, and because they were not at home, at the respective homes. Number 1, Lordship. Number 2, Lordship, I beg to state that it has been reflected in the order passed by this Honorable Court, Lordship, on 20th of April 2023, whereby, Lordship, at page 4, Lordship, I'll just read it out. It has been recorded from the statement of the counsel for the petitioner, the applicant rather, it could not be imagined. Lordship,
What
at page 4, Lordship, the order passed by this Honourable Court.
paragraph?
At paragraph 7, Lordship, but at page 4.
Page 4. Page 4.
Yes. If I may read, Lordship. The Learned Counsel also submitted that the inclusion of Section 307 is only to allow the police to immediately arrest Juma Khan and others when prima facie it is noticed that the informant himself had stated that after the alleged incident he was seriously injured but had returned to Silchar. It could not be imagined as to how he managed to ride back to Silchar, which is about 299 kilometers from Shillong, on his bike. Lordship, I beg to submit this CD before this Honourable Court, and I have flagged this taxi receipt, Lordship, whereby the victim had travelled by taxi and not by bike, as alleged by the counsel for the applicant, Lordship. This is from Shillong to Silchar, Lordship. His hand was broken. There was no way he could have travelled by bike, Lordship. So that is the, as per investigation, this is what the police have gathered, Lordship. That's the second ground for objection, Lordship. Thirdly, Lordship, my friend had brought up the reason for the concept of delay, Lordship. The fact of the matter is that the victim had been beaten up and he was scared for his life. So he went to Silchar. And that's why there was a delay in filing of the FIR. That is the reason as per the investigation of the police, Lordship. Now, the fourth ground, Lordship, is on perusal of the statement given by the witnesses, Lordship, they corroborate each other. The statements were taken separately, but they corroborate each other. And on the fifth and the last ground for objection, Lordship, my friend had relied on the bail granted by this learned court. I pray that that be not considered, because that prayer and the grant of bail was on medical grounds. There is no medical ground over here. Right from the subordinate court, the trial court, Lordship, they keep on inquiring from the applicants, their health, and they always respond in the positive manner that they are okay, Lordship. So on these 5 grounds, Lordship, I strongly object to the bail application.
Sure, I just submit one line to what my learned friend has addressed this Honourable Court. Of course, this is my humble submission. Bail or arrest or the pre-investigation period, Lordship knows very well that it cannot be used as a tool for a pre-conviction, pre-trial conviction. My submission is that much.
That's true, but generally court when dealing with bail matters would rely on the facts and circumstances
Absolutely,
of each particular case. Number 2, the consideration would be the.
Now my submission.
The court will have to go through the progress of investigation.
Absolutely.
And as to the complicity of the the petitioners, and of course the gravity and seriousness and the sentence involved would have to be taken into account.
Absolutely, Lordship. My only submission before Lordship.
I'll go to the CD and
Lordship. Can I just add one line? My only submission before Lordship, so far petitioner number 1 is concerned, that he has travelled from Delhi to Guwahati, then to Shillong to appear before the IO. This itself shows that they always want to cooperate with the investigation. So therefore, perhaps, deeply obliged.
Lordship, I flagged the necessary pages, Lordship, but the X-ray shows that metal sheets have been attached to the victim's hands, Lordship.
Fine.
Much obliged, Lordship.
Just place some documents taking indulgence of your Lordship. So far, one of the witnesses concerned, one of the accused is concerned, accused number 2, Lordship. There's some documents from his office asking him to appear on 28/12. Otherwise, he's working as a regional manager in a medical company, Lordship. Otherwise, perhaps he will be losing his job.
We have not been supplied with those copies, Lordship.
Yes, certainly. We'll give a copy. We'll certainly give a copy. 2 sets are there. Mistakenly 2 sets went there. We'll give a copy to you.
Yes. So I'll go to the papers and I'll pass the orders.
Much obliged, Lordship.
Item number 4.
For the private respondent in this matter.
Please, Your Lordship.
Yes.
Please, Your Lordship. Lordship, senior counsel is on legs before. Go to. But I'm instructed to place the facts before Your Lordship. Lordship, if I may be allowed to place the fact.
Yes, please.
Lordship, in this matter, we are challenging the termination letter. 1. 2. 3. 4. 5. 6. 7. 8. 9. 10. 11. 12. 13. 14. 15. 16. 17. 18. 19. 20. 21. 22. 23. 24. 25. 26. 27. 28. 29. 30. 31. 32. 33. 34. 35. 36. 37. 38. 39. 40. 41. 42. 43. 44. 45. 46. 47. 48. 49. 50. 51. 52. 53. 54. 55. 56. 57. 58. 59. 60. 61. 62. 63. 64. 65. 66. 67. 68. 69. 70. 71. 72. 73. 74. 75. 76. 77. 78. 79. 80. 81. 82. 83. 84. 85. 86. 87. 88. 89. 90. 91. 92. 93. 94. 95. 96. 97. 98. 99. 100. 101. 102. 103. 104. 105. 106. 107. 108. 109. 110. 111. 112. 113. 1
dated 17/8/2016.
Yes.
Termination letter is at page 16, Your Lordship, Annexure 1. Sorry, Your Lordship, page 4, Your Lordship. Page 4, page 41, Annexure 4.
Page 41 or?
41 of the petition, Your Lordship. Lordship, this is termination letter issued by the Office of Deputy Accountant General.
Yes.
Lordship, the petitioner was appointed on.
Yes.
Yeah, Lordship. Letter states that in terms of headquarter letter so and so dated 26/7/2016, the following home guard are hereby informed that their service are no longer required by the office, and hence this may be treated as a 1-month notice from the date of issue prior to this termination. Lordship, in the first place, a petitioner was appointed on 30/08/1990. That is page 16, Your Lordship, Annexure 1.
Page
16, Your Lordship, Annexure 1. Type copy is on the next page, page 16A. Lordship, may I read, Your Lordship?
Please.
Subject to discharge without a notice and without assigning any reason, therefore Shri Thiran C. H. Rai and Shri Gulab Sinha Sinha is temporarily appointed as a guardman in the scale of pay so-and-so plus other allowance as admissible under the rule with effect from 1st August 1990. The appointment is against the requirement of AG office Shillong and will remain valid as long as the requisition authority concerned requires the service of the Meghalaya Home Guards volunteers. Should the service be no longer required, no claim for absorption in any unit of the Home Guard / civil defense will be entertained. They will be liable to discharge from the post without assigning any reason thereafter if there are any lapse adverse report against them. Lordship, if I may take Your Lordship to Annexure 3, Your Lordship.
Annexure
3, Your Lordship.
Annexure
3.
Page
18, Your Lordship.
Yes.
Lordship, may come to page 21, para 3, Your Lordship. Page 21, Your Lordship.
Page 21.
Para 3, Your Lordship.
Yes.
Lordship, may I allow to read?
Yes.
The Government of Meghalaya has the petition, it case being in brief thus. The petitioner were appointed against the requirement of the guardsmen in the AG office Shillong, and while appointing them had been made clear to the petitioner that their appointment will remain valid as long as the requisitioning authority required and the service of the petitioner, and should the service be no longer required by the requisitioning authority, no claim by the petitioner for the absorption in any of the unit of the Home Guard in civil defense will be entertained by the Government of Meghalaya. Department of Home Guard and Civil Defense is only a nominating agency which caters to the need of the requisitioning authority like AG office. The petitioner appointment are valid so long as the requestioning authority require the service of the petitioner. Hence, the question of absorption of the petitioner in any of the department of state government does not arise at all. The petitioner have willfully accepted the condition of their appointment. They are volunteers. The deployment fall directly under the requestioning authority and leave. Financial benefits extra are given by the requestioning authority agency, and the Department of Home Guard and Civil Defense is only a nominating agency. However, the state government has no objection if the requestioning authority opts to pay the petitioner the scale of pay as available to regular Home Guard under the state of government. District Commandant Home Guard is Kasil Shillong had merely kept the request of the AG office as regard the revision of pay scale as a good gesture. Though the district commandant had certified in the past the increment which the petitioner eventually received, the same was stopped by the district commandant as service of the Home Guard are purely on temporary basis. So long as the requestioning authority require the service of the petitioner, they will be continue to remain in service, and whenever the AG office decide not to retain the petitioner, engagement of the petitioner will be terminated. The service of the petitioner falls under the service condition of the requesting authority. The practice of leave, which used to be sanctioned by the District Training Center Shillong, has been stopped, and the requesting authority has been given the power to grant leave. The petition is wholly without. Let me skip that part, Your Lordship. Lordship, here what happened is that the petitioner were appointed as by the requesting authority as the guardsman. But Lordship, as per the judgment dated 12/10, Lordship, the petitioner cannot be terminated from service, Your Lordship, as long as the service of Home Guard are required. Lordship, I may take to para Lordship, page 29, para 17, Your Lordship.
Para
17, Your Lordship. For microscopic reading of the letter of appointment, what clearly surfaces is that there are three discernible conditions of the contract and namely so and so. Lordship, we come to 1, 2, 3, 4, 5th line, Your Lordship.
Yes.
Lordship, here it says that the petitioner were to remain under contractual employment so long as the service were required by the AG office. Should therefore the AG office did not require the service of the Home Guard, the petitioner's service were to be terminated.
Yes.
Lordship, may come to page 32, Lordship, para 22.
Yes.
These are in this part, the question now is as to how long the petitioner will remain under contractual employment. In this regard, the order of appointment stated that the petitioner will remain under contractual employment so long as the service are required by the AG office. It needs to be, Lordship, it needs to be noted that the requirement of the AG office was not personal specific, Lordship, meaning that the requirement of the AG office is not personal specific to the petitioner. It requires the service of the Home Guard, Your Lordship. Consequently, as long as the AG office required the service of petitioner as Home Guards, the petitioner were promised to be kept in employment. Lordship, para 23.
Yes.
Is therefore neither open to the AG office nor to state government to replace the petitioner by any other sets of similar or other employees. The petitioner can be removed unless otherwise indicated by law only when the AG office make it clear to state government that they no longer require the service of Home Guard.
Yes.
Lordship, as per this order, Your Lordship, passed in this WPC SH number 250 of 2005, it clearly states that the petitioner cannot be terminated from service, Your Lordship, unless the requisitioning authority does not require anymore the service of the Home Guard, Your Lordship. But Lordship, requisitioning authority issuing termination letter is very highly illegal, Your Lordship.
Yes. Anything else?
Lordship, we take to para 9, page 9 of the petition, Your Lordship.
Yes. What does it
That
say?
the petitioner state that after delivering considerable period of time, that is about 26 years in service, to the utter shock and surprise of the petitioner, the respondent number 9 white impugn office order date number so and so dated so and so informed the petitioner that in terms of the headquarter letter number so and so dated so and so, the service of the petitioner are no longer required by the office of Accountant General Shillong, and therefore to treat the said order as 1 month notice prior to his termination. It's pertinent to mention here and that the petitioner has now learned that the respondent are seeking to replace the petitioner by untimely terminating him from service on the ground of non-requirement of his service by the department by appointing other candidates as has been done in the case of Shri Sukh Bahadur Gurung, in whose retirement the respondent has now appointed an employee in a much less emoluments than what the retired employee used to be paid. Further, the facts that the said employee on retirement has been replaced with a new employee will show that the respondent still required the service of Home Guards contrary to what has been stated in the impugned order. Assembly submitted and the termination order has been issued by the respondent only to do away with the financial benefits that the present petitioner are entitled to by replacing them with employee in a much lesser salaries than what the present employee are receiving. Lordship, as per the order dated 12/10, Lordship, the petitioner cannot be terminated from service and replaced by some employee, Lordship, because the work assigned is not personal specific, Lordship.
Yes. Yes, Mr.
You receive here this the order of termination of the address in this office of the AG office no required for the Home Guard at that present stage when this order was issued. And by virtue of this stay order granted by this Honorable Court, last question petitioner says this they've already been superannuated as per age and then they've submitted.
They are only.
But the last question they say that so elusive. After that, they're supposed to file the affidavit in this regard, but not yet filed any affidavit.
What is the status of?
In this case,
just
only 2 of them retire, Your Lordship.
Have you filed any affidavit to that extent?
No, Your Lordship.
You should have. You should have brought that on record.
Yes,
now you have made a submission on the premise that they are still in service, albeit you see on the strength of the stay order by this court.
Lordship, then I may be allowed to file a affidavit, Your
Should
Lordship.
have done that. How many petitioners are there altogether?
3, Your Lordship.
So you see in my paragraph 17, it's page 7.
You should have, Mr. Debna, I think we'll have to wait for their. You file that affidavit, bring on record the status of the. If they are out of, if they are, they have gone on superannuation, then no, they have no more case. What is the question of continuing with their appointment or their?
Your Lordship, one petitioner is still in service, Your Lordship.
Your Lordship, here in this case, main issue is there that they raised in this petition that AGOPC intend to replace the petitioners by other person, but it is not correct. It is stated
You
in
have,
our.
you have filed your affidavit.
Yes, Your Lordship. In this paragraph.
Then we'll
17.
deal with the status of the petitioners.
So this in the appointment letter was there. That's as our requirement will give, not after that. So in paragraph 17 we have stated, let's say the last paragraph, then page number 8. The allegation of the intent to replace the home guard, any other sets of similar or other employee is an afterthought and argument. So we have clearly.
Let them file the affidavit first. Then a counsel for the petitioner has submitted that the two of the petitioners herein have since superannuated. However, it is prayed that this fact may be brought on record by way of an additional affidavit. Accordingly, the petitioner are directed to file their affidavit as prayed for. List this matter after 2 weeks.
2 weeks, Your Lordship.
2 weeks. Before you start your submission, you should have brought that to
My
notice.
apology, Your Lordship. Lordship, in this petition and WPC number 261 is still in service, Your Lordship.
Yes, so you file your affidavit. Okay.
Item number 14.
Highly obliged, Lordship.
Lord, I have filed my written argument, my lord, today.
There should be a file or note of objection.
You have filed?
Yes, Lordship.
I have also filed on my part, my lord.
When was this matter last heard? Mr. Sunkan, you can just refresh the court on what you have earlier submitted.
My lord, this is regarding that one lady who died during her delivery in a non-possible hospital, my lord.
Okay.
Because she was taken at that point in time when she delivered the baby at home. Thereafter, she was taken by rickshaw to the hospital, my lord, and she was left unattended for 25 to 30 minutes. And crucial time, my lord, she was not attended, and she has lost lots of blood, my lord. She needed some blood transfusion. That was not done, and ultimately, my lord, she lost her life. So because of that, my lord, I filed an application because there was negligence on the part of the state also, and even the ASHA worker, my lord, who is supposed to be equipped with the delivery kit and some injection that is called oxytocin. If that injection is pushed at the right time, my lord, it helps the placenta to deliver automatically, my lord. My lord, that also was not available, and then it was not injected at the right point at the time when it was needed, and this has resulted in placenta retention, and thereafter, my lord, she expired. So because of which, my lord, I have claimed for some compensation, and because she is having 4 children, my lord, minor children, so she has been looked after only by the mother of the deceased, my lord. So therefore, my lord, I have prayed that some compensation should be paid to the petitioner, my lord.
Who is the petitioner?
Petitioner is the mother of
the deceased,
my lord. She is the one who is looking after the baby, all the 4 children, and they are financially not in a good position because it's a duty of the state, my lord, under Article 21, because to provide some proper health care, my lord. Now, if a person has died due to lapses on the part of the state, now, my lord, she is entitled for some compensation. That is all my case, my lord.
Have you cited any authority?
My lord, if I can give one submit, my lord, I'll try to find out.
See, always back your case by relevant authority.
My lord,
You have not cited.
my lord, I have not cited. If in case I'll submit a copy, my lord.
Yes. What is your
We have cited in the note of objection.
what is your response to the submission?
Your Lordship, actually the petitioner's, the deceased was brought there to the hospital.
Yeah.
So it was their negligence.
Their claim is that we brought her there.
Yeah, you have made a submission. So
Yes, and then she gave birth at home for 3 children. Like the first, second, and third, she gave birth at home, and then the fourth one also, Your Lordship. And after giving birth, due to the heavy bleeding, that's why they took her to a hospital. And that also, like, she already brought very late to the hospital.
have you got any proof for that?
Should we have filed the
Any medical, any report, any examination done? What was the result of the examination?
It was already he was. Lordship. The medical report was there, Lordship.
You have filed your affidavit.
Yes, Lordship.
So tell me, have you stated all this in your affidavit? Excuse me.
We have annexure, Lordship, annexure 1.
Yes. What does annexure 1 says?
It is a notification order by the government on the Secretary of Government of Meghalaya Health and Family Welfare. So, on expiry of the period of lien as senior resident doctor in respective department, Nigrims, Shillong, the following doctors are posted at the place indicated against the names with effect from the date of taking over charge and until further orders.
What does this say? What does this say about the case?
Lordship?
No, what does this say about the case?
Lordship, this is not the relevant annexure.
That is pertaining to one doctor. That anesthesists were not available at that point in time in that hospital,
Yes,
madam.
Lordship.
So he was transferred in some other.
Miss, you go through your case properly. You study the matter properly, and we'll take it up after 1 week. And in the meantime, you file your
I'll file my judgments.
claim made by the parties. Let's this matter after 1 week.
Obliged.
Item number 15.
Please, Lordship. Lordship, the conducting counsel still sound like Lordship. Please. Mr. Paul.
My lord, I have objection, my lord. This is matter, my lord, is unnecessary delete. And if they wanted to mention, my lord, they could have mentioned the mentioning hours.
Lordship,
That has not been done. I had basically personally spoken to Mr. Paul, my lord. about regarding this
No, but
case.
he's
He
on-
had expressed his difficulty saying that this case, but in none of them they have come forward to mention it, my lord. They have made us wait for the whole session, and at the last moment, my lord, they are convenient.
That is.
They should not play with us, my lord.
Your Lordship, we thought
That
that
is
it will
something
be
very
finished.
unethical.
That's why, Lordship, you have to wait.
Something very wrong to do, my lord,
No,
and
but-
it repeatedly happens, my lord.
Mr. Charji, even in the earlier case also, the prayer was made that he is on leg in the other court.
My lord.
So would he perhaps the anticipation that he will be available as and when the matter
That
is
is
called
not.
up?
That is why, my lord, I have said, my lord, that I had spoken to
Fix
Mr.
tomorrow. I pray tomorrow, Your
He
Lordship.
personally, basically, he said he's expressing inability, my lord. But thereafter also, my lord, I was waiting. I thought, my lord, since the court proceeding, it becomes my duty, my lord. Because what happens, we cannot take it as granted, my lord. My lord, at the mentioning hours, my lord, they do not have the courtesy, my lord, to do that. That is why. There is something very improper to do, my lord.
We thought that it will be finished, Your Lordship, by this time.
Even then, you see, if the Leonard, he's a senior counsel is standing at the bar, that respect should have been there. If Mr. Paul has indicated that he may not be able to appear in this case, then that should have been conveyed to you and to the court.
Apologize, Lordship.
Please be careful in all these matters. This is a decorum of the court. Mutual respect has to be there. And pray made by the petitioner. This is matter after 3 weeks.
Leo, please.
So